Up next, the Cannabis Reporter Radio Show with Snowden Bishop. After this message.
Evergreen's calling.
Most people don't realize that cannabis is serious business that requires serious technology solutions. Hi, I'm Terry from Sunstate Technology Group, where we are seriously proud to provide technology and security systems that help cannabis companies compete and succeed. From planning and expansion to hardware and daily IT support, I'm here to tell you that having the right technology is critical to security and smooth business operations. Partner with a technology team that understands the unique needs of this industry. For details, visit sunstatetech.com/cannabis. sunstatetech.com/cannabis.
And now, it's time for the Cannabis Reporter Radio Show with Snowden Bishop. Listen in as Snowden interviews cannabis industry pioneers, marijuana experts, policymakers, medical practitioners, patients, and other amazing individuals with compelling stories to share. It all happens right now. Here's the Cannabis Reporter, Snowden Bishop.
Hi, and welcome back to the Cannabis Reporter Radio Show. I'm Snowden Bishop. Thank you for joining me. If you were with us last year, you might recall an interview with attorney Tom Dean about the Rodney Jones case, which had devastating implications for Arizona's medical marijuana program. In case you missed it, let me bring you up to speed. Rodney Jones was a card-carrying medical marijuana patient who was arrested in 2013 after a traffic stop when officers found him in possession of hashish, a cannabis derivative he had purchased legally at a licensed dispensary. A year later, after prosecutors sufficiently convinced a jury that the hashish in his possession was not marijuana as defined in the Arizona Medical Marijuana Act, but rather cannabis, which is illegal to possess or consume under Arizona Criminal Code, Jones was convicted of felony possession and sentenced to a mandatory minimum sentence of more than 3 years in state prison. He spent 2.5 years of that term in prison before his appeal could be heard, and when appellate court justices ruled in favor of the prosecutors, they sent Rodney Jones back to prison to serve out the remainder of his sentence. This definitely was a case of being in the wrong place at the wrong time. He was arrested in Yavapai County, jurisdiction of the infamous prosecutor Sheila Polk, who is famous for her loud opposition to Arizona's medical marijuana program, and her prosecution of Rodney Jones was a huge win for her. The appellate court ruling essentially gutted protections for the vast majority of Arizona medical marijuana patients who rely on extracts for medical reasons, as most patients do prefer not to smoke their medicine. So despite the obvious voter intent of the measure, by interpreting the Medical Marijuana Act's definition of marijuana to include only dried smokable leaves, all tinctures, resins, vape products, edibles, and topicals containing extract were rendered illegal for patients to use. That changed last week with a resounding win in the Arizona Supreme Court, which reversed the appellate denial and exonerated Rodney Jones. This ruling determined that cannabis extracts and resins would now be deemed legal for qualified patients to possess and consume. That's the topic of today's show, and I'm very excited to say that the attorneys who were intimately involved in the Supreme Court case for Jones are here to discuss it. Rob Mandel is a seasoned appellate and trial court litigation lawyer and founding partner at Mandel Young, where he specializes in high-stakes commercial, constitutional, and public law disputes. He was the lead attorney arguing on behalf of Rodney Jones at the Arizona Supreme Court hearing. Attorney Gary Smith, also a member of the legal team, is a partner at Smith Sachs Kuzmich, where he specializes in cannabis law, and he also happens to be the president of the Arizona Cannabis Bar Association. Rob and Gary, I'm so glad that you're here to talk about this. I've been very excited to interview you about the Jones case, and I'm glad that we could finally do it. So thanks for being here.
Oh, it's absolutely our pleasure. And thank you, by the way, for being patient. I know you were wanting to get us on an interview during the pendency of the case, and we kept putting you off because the case was still pending, so we appreciate your patience as well.
Well, you know what? I've already covered this on a couple of different interviews with a couple of different attorneys because I've just found it so astonishing that a card-carrying medical marijuana patient was arrested for carrying drugs that he purchased legally in a dispensary. I mean, that just goes so far beyond what seems normal to me. And how is Rodney doing right now?
Well, this is Robert speaking, and what I can say is that Rodney is in really good spirits as a result of the decision, and I think he's really looking forward to getting his life back because he has had to endure not only the 2.5 years in county jail and then in the state prison, but he's thereafter had to serve 2.5 years of probation and live with 2 felony convictions on his record arising out of this case. And that can be paralyzing for somebody who is looking for a job and wanting to advance their life.
Well, absolutely. And by the way, congratulations on an incredible win.
Well, thank you. Our objective was to help a person in need. We didn't realize we were going to be making history, but we'll take it. We're delighted by the result.
I can only imagine. And Robert, you were actually arguing the case in front of the Supreme Court in Arizona. Is that correct?
I did, yes.
Yeah. And did you also represent Rodney through the appellate court?
No, Rodney had another attorney representing him at the Court of Appeals level, as well as a couple attorneys, not at the same time, at the trial court level. And it wasn't until the decision came down at the Court of Appeals that efforts were undertaken to find an attorney with appellate experience who could muster the time and energy needed to bring a case to the Arizona Supreme Court.
And that's quite a process, I understand. How hard was it to convince them to actually hear the case?
That's hard to say because, of course, you're never in the room with the justices as they're deliberating about whether to take a case. So you have to look to things like statistics in order to answer questions like that. And without digging too deep in the weeds, I think it's safe to say that the statistics show that the Supreme Court takes very, very few cases, and in the criminal sphere, even fewer. So the chances of having a decision by the Court of Appeals accepted for review by the Supreme Court is excruciatingly small.
And this is Gary. I think also there was a little bit of what I'll call political weirdness that took place early on in the case relative to which state agency was actually going to assume responsibility for the appeal. The petition to the Supreme Court obviously originated with Rob Mandel filing a petition on Rodney's behalf, and then the case was taken up first by the Arizona Attorney General's office, who along the path during the course of the petition handed it back to the Yavapai County Attorney's office. And I think it's probably appropriate to actually give a little hat nod and an acknowledgement to the Arizona Attorney General's office for a couple of things in that process, inclusive of which were that the Attorney General initially opposed the petition, but then reversed course and actually filed a withdrawal of that opposition, indicating to the Supreme Court that even the Attorney General's office believed that this merited review, and they expressly asked that it be reviewed. That was tremendous. And again, I want to acknowledge the Attorney General's office for doing that. Additionally, on my part of the case, I represented one of the amici parties, Will Humble, who's the former director of the Department of Health Services. And true with every amici party, you either need to get permission from all the litigants in the core case, or you need the Supreme Court to grant you the right to participate. And here again, the Attorney General very graciously consented to Director Humble's appearance, and thus we entered an appearance and briefed Director Humble's issues.
So in case you're wondering, Gary mentioned the word amici, and what an amici is it's a Latin phrase. The phrase is actually amicus curity, which means friend of the court. And so in this case, there were several friends of the court that filed briefs in support of the legal arguments that we were making on behalf of Rodney.
You read my mind, because I was about to say that there were a number of rather prominent attorneys who wrote amicus briefs to the court. So thank you for clarifying that. And I mean, how active, Gary, was the Arizona Cannabis Bar Association?
There's really nothing that the Bar Association did or does in that regard. Each amicus party or amici party independently does their own briefing. In my instance, I did a brief for Will Humble. The Cannabis Bar Association itself, though, didn't appear in the case. It was really just me in my separate professional capacity. Reason being, the Cannabis Bar Association is formed to be an educational group, not a political advocacy group. And we talked about it amongst the board members of the Cannabis Bar Association. And without giving you too much glimpse inside, I can tell you that there was unanimity of opinion on the board that Rodney's case was absolutely worthy. And there was unanimity of opinion that the Court of Appeals' decision was the wrong one and it needed to be reviewed. But we did all ultimately agree that the Bar Association had to stay neutral, because that is its core function, is to remain neutral and just offer public education.
Right. So that's interesting. And with all bar associations, I mean, they really do have to stay rather impartial.
Yeah, absolutely.
Yeah. But I mean, but the work that...
I'll flesh that out a little bit more, Snowden, if I can.
Yeah.
The Cannabis Bar Association is open to any attorney in good standing in Arizona. We don't discriminate based on beliefs. In point of fact, we have a variety of members who have a variety of opinions about cannabis. Some folks stick to the position that it should be strictly medical. Some of our other folks think it should be open to recreational. Other folks think it should just be sort of a libertarian free-for-all. And I would be surprised, but I certainly welcome, we might have folks amongst us who are openly anti-cannabis. We don't discriminate. We welcome all voices because we use the association as a bridge to help facilitate communication between those camps. Right.
And how cooperative was the Yavapai County prosecutor's office in this appeal? I mean, I'm saying that sort of tongue in cheek because I know how bitterly against cannabis that office happens to be.
Some people in the office.
Well, yeah, one in particular that I can think of.
There you go.
Yeah.
Snowden, this is Rob. Once you're at the Supreme Court level, there really is very little interaction between the opponents in terms of the proceeding itself. There are deadlines set. There are briefs that are filed on those deadlines. The only interaction that takes place is that each party has an obligation to serve their papers on the other side. And so there were no discussions other than perhaps a request here or there for an extension on a deadline. I think that the real fireworks take place at the trial court level. That's when you're going to find the telephone calls and the meetings between defense counsel and prosecutors in hearings and so forth, where the sort of thing that you're alluding to will sort of ring true. Yeah.
Did you ever get the impression that the original prosecution of Rodney Jones was more of a political stunt?
Well, I try to stay away from sort of the policy discussions like that, but there is no question that the county prosecutor in Yavapai County has been the staunchest of opponents of the Medical Marijuana Act and does anything and everything within her power to impose limits on the act and the scope of the act through the judicial system. And so